Hello, this is Heejun, and I'm a lawyer in South Korea. Today, I want to talk about the software development delays in Korea and the responsibility from it. Uh, there are many Korean companies working with foreign partners on developing the programs and things like that. And let's assume a situation in which your Korean software developer missed the deadline, for example, by 3 months. Your head Coral canceled the contract, and the emergency replacement cost then you had to pay for the delay um, cost you double. So, for example, then your question should be how much or whether it's possible then you claim damages from it. And this is basically the topic which I would like to deal with for today. So, translation here is a little bit weird, but software development is basically a contract for work, the Korean law. So, if the developer fails to deliver on time, then they are basically liable for breach of contract under Korean Civil Code Article 390 and 392. And also, Korean Software Promotion Act Article 38 requires contracts to specify work scope and change procedures and penalty clauses, and all those codes are basically what you need to claim your damages. So then the most important question should be what kind of damage you can claim and how much. So the first type of damage that you can think of is liquidated damage. So if your contract includes penalty clauses, so for example, typically 0.25% of contract value per day of delay, then it's probably or likely that Korean courts enforce this. So, which was first the case actually in Seoul Central District Court in a case. And then the second type of the damage that you can think of is actual damages according to civil law, and additional costs for emergency outsourcing qualify as ordinary damages to say. So penalties paid to your company can be claimed as special damages as well if the developer knew or should have known about this kind of risk. So the third point that you have to keep in mind for this kind of cross-border disputes is that international elements in the contract essentially matter. So like the jurisdiction and the possibility whether there is an arbitration clause requiring ICC or other international arbitration. Because winning in Korean courts doesn't automatically mean enforcement in Europe. So you will need separate recognition proceedings. So and furthermore, language barriers matters as well, as you can think of. The documents could be in English, but the internal communication within your company about this issue could be in German or in French, which could be used also as evidence. So the language matters as well. So the things then you have to prepare for this kind of problem or dispute is gather your original contract and amendments and documents providing the deadline and evidence of delayed circumstances and proof of replacement development costs and evidence of damages paid to your final client and etc. I would like to recommend to try negotiation first because international litigation is expensive, as you can probably imagine, and also it's very time consuming. So it would be nice if you can get the compensation just by the negotiation. But to conduct this kind of negotiation, um, doing this with the legal counsel, which understand your language and Korean, it's going to be more favorable for the better result in terms of the communication and the level of the understanding of evidence that you have. So um, software development delays can threaten your entire business, and with European companies involved, language barriers and different legal systems can cause irreversible damages if you respond too late. So I myself worked as a legal counsel in France, and I also can speak a decent level of German, English, and French. So if you find yourself in such a situation, then I would be delighted to be helpful to get rid of this kind of problem for you.